Chair.
Good morning. Good morning. Can we have apologies? Are there any apologies? I think on my side we have two apologies from Honorable Janji and Honorable Nola. They are attending the Chapter 194 inquiry. Are there any other apologies? No apologies. Honorable members, I've been informed that Honorable Dr. Mulder will be joining us for today, but I have not yet seen him. He is welcome in advance. Can we continue from where we left? Over to you, Mr. Dupree, DDG Kayla Pillay, and Ms. Botha. Can you take us through?
Morning, Chair. Thank you very much. And good morning to your members and Deputy Minister. I will share my screen. What's going on? Oh, shucks. Mr. Chair, please just bear with me. Something just went terribly wrong here. There we are. Mr. Chair, yes, just to recap on Friday's meeting, the committee indicated to the department that options must be prepared with regard to the definition of harm, and the committee has gone through I think we should, if I remember correctly, we should now be at the definition of characteristics. Those are the characteristics that are being defined for purposes of Section 3, or Clause 3, the hate crimes provision. I don't know whether you want me to pause here with this definition and maybe receive questions. The department can indicate to the committee that with regard to the definition of characteristics, Section 16(2) and then 9 of the Constitution were taken into consideration, and then also PAPUDA. The characteristics were not copied willy-nilly. You will note that, for example, pregnancy is not included in the list, and also not marital status, because those characteristics relate to equality provisions and not necessarily hate crimes, and that's why they were not included, Mr. Chair. May I proceed, Chair?
Yes, there are no questions. I don't see any hands as yet. Let me check. I'm using a new device, so members bear with me. Are there any questions? I don't see any. You can proceed.
Chair, it's Werner Ron. My hand is up.
Okay, Honorable Horn, proceed.
Yes, Chair, I'm obviously in the disadvantaged position that we're not able to attend on Friday, but the way Mr. Dupree explained where we are now, I am then to assume that we have not dealt with in final detail with the so-called justification document the department tabled previously around the characteristics. I would be of the opinion that we as a committee must look at each one of those justifications. I don't think it's necessary to repeat the previous argument around specifically the characteristics and whether the characteristics can in a constitutionally compliant manner inform criminalization in all instances. But we did previously indicate that we in respect of that specific document, were of the view that in one or two instances, it would seem that they were made out on face value, a good case for criminalization or including that specific characteristics. However, and unfortunately so, in respect of a number of the other, the so-called justification rather seemed like the product of and I'm choosing my words carefully so not to use fighting words early on in the meeting, but it would seem that some of those characteristics were, or the attempted justification were rather the product of a Google search or of the words, and that any reference to some of those characteristics were then included in that document as a so-called justification, and that cannot, in our view, be sufficient to convince the committee. So I would suggest that we must, at this stage, if we have not on Friday, return to that document and deal with the so-called justification of each of those. In respect of one of them, birth, I am not aware that we've received the updated document. When we were initially briefed on the document, there were a verbal supplementation of the issue of birth, but I've not seen the updated document that includes specifically birth, unless I've missed it. Thank you.
Thank you. Honorable Swart.
Yes, thank you, Chair. I understood this was the time when we were going to debate each one of these issues, and that would then involve the consideration of that working document and to understand the motivation for the inclusion of every one of these characteristics as we go through. So I think I want to just support what Mr. Horn says, in as much as that document would seek to justify issues, and then the department can also say, well, this was taken from the Constitution, Section 16, Section 9, and from Papuda, or if it's not there, then what are the reasons for it? I appreciate what Mr. Dupree said. Some of the characteristics were not included because they were equality provisions. But I think we would need to look at each one of these and the motivation for the inclusion. Thank you, Chair.
Thank you. Honorable Masako Jala.
Thank you, Chair. Good morning. I think, Chair, let me not deviate from what my colleagues are saying. Let's hear what the department is going to say. But my question was going to be also the characteristics means any of the following characteristics. I'm reading from the document. And then when you go down, it says grounds bears the same meaning as characteristics. No, don't go far. Don't go far. It's still the same sentence up on the beginning of the characteristics. I was just reading that one that says characteristics means any of the following characteristics, and then you'll name them. And then when you go down to the ground, you are saying grounds bears the same meaning as characteristics. And I will wait for also the response of that when we are dealing with that document as requested by my colleagues. But I was going to request, because it seems as if there are those that are not added now on the ground, those characteristics. So I was going to propose, Chair, to add from the characteristics to bring some down to the grounds.
Members, I would propose that let's first deal with characteristics. Let's follow the bill as structured now before we move to the grounds. Once we are done with the characteristics, then we'll move to the grounds. We are still dealing with the characteristics. I think let's follow that order, because if we don't, then we'll move from clause 1 to clause 30, clause 5, and then I think let's just move chronologically. Honorable Breitenbach.
I'm struggling to unmute, forgive me. Thank you. I'm covered by Mr. Swartz and Mr. Horn. Mr. Chair, thank you.
Thank you very much. Honorable Mulder.
Thank you, Honorable Chair, for allowing me, accommodating me. At this stage, I was covered by Honorable Horn and Honorable Swartz. I will ask a question later.
Yeah, no.
Honorable John Jeffrey.
Thanks, Chair. I don't know how I'm looking, but just to emphasize the point, I think you've covered it. I mean, characteristics are about hate crimes. Grounds are about hate speech. And a hate crime is the underlying crime, as well as the motivation that was committed by a person who's motivated by their prejudice or intolerance towards the victim, based on the characteristics. So, I'll just remind people on the hate speech provisions, but that's what we're looking at: existing crime that becomes a hate crime because of these, the motivation being on any of these characteristics. Thanks, Chair.
Thank you very much. But Deputy Minister, on the face value reading of the bill, would a person without your explanation reading the bill, because they're just characteristics which are tabled, and then you have grounds, will the person reading the bill without this explanation, let's say a magistrate or any presiding officer, be able to distinguish that this is for hate crime and this is for hate speech? Because I would think that it should be clear from the bill in the way that it is crafted.
Chair, if you remember, the introduced bill had the characteristics in the body of the bill. So if clause 3 is the offence of hate crime, and that then had the characteristics there. It was taken out from the point of view of better reading, to put it under the definition section. We would hope that lawyers, I mean, remember, we're not writing a bill for the general public. We can do that by explaining things about a bill. The issue of a bill is legal certainty. But one would hope that the magistrates, the prosecutors, well, there would be training for them, but that they would look at the definitions clause. But yeah, it was in the original clause 3, which for that reason got moved out as a proposal that it makes clause 3 and clause 4 read better without having them. But we can put it back.
Yeah, I do follow a different line of thought, in the sense that for me, the way we should be drafting laws, it should not only be for lawyers and academics, and because some people represent themselves. It should be such that it should be for the people of South Africa. So I think there is a resolution of a certain organization that I think in 1997 said that the law must be written in such a way that even an ordinary person, we must strive to write it in such a way that even an ordinary person can be able to read and follow the law.
Mr. Chair, I'm sorry, may I come in here, please? I'm struggling to raise my hand, so I apologize for that.
Okay.
Mr. Chair, if a prosecutor decides to prosecute a person for a hate crime, it's up to the prosecutor to present that case to the court. And in presenting that case to the court, the prosecutor will naturally have to guide the court and explain to the court how the definition of characteristics then fit in to clause or then eventually section 3 of this bill. So I would like just to mention that to you as well, Chair. Thank you.
Thank you. Thank you. Are there any comments on this, Honorable Ms. Botha?
Thank you, Chair. I also just wanted to say, in terms of the usage of characteristics and the usage of the phrase grounds, it's quite clear that in clause 3 we talk only to characteristics, and in clause 4 we talk only to grounds. So if you read the definition of characteristics with clause 3, then it is one sort of composite understanding. And if you read the definition of grounds in relation to clause 4, then that is one composite understanding, so that there is no confusion between the two. Characteristics is only used in respect of clause 3, and grounds only in respect of clause 4. Thank you, Chair.
Mr. Chair, I would also like to add, and there's a very good example for that, and that is in the Protected Disclosures Act, where the characteristics, the definitions are printed in italics, and where they are used in the different sections of the Act, they are also in italics. I personally don't prefer that, but and that was a practice that was soon disbanded by the state law advisors. I don't know whether they would like to mention something on this, but that is an option, just to make it absolutely clear that characteristics only apply to clause 3, and then the grounds to clause 4. However, as the Deputy Minister said, this is merely a proposal for purposes of clarity, and it is up to the committee to decide how the committee would like to approach that. Thank you, Chair.
Thank you. I think let's take note of that, and maybe if we feel that we are still not clear, I think we will come back to it. But I think let's proceed to the issues raised by other honorable members about the definition of each. I think it was raised by Honorable Swart and Honorable Horn, supported by Honorable Glenis, under characteristics.
Chair, I do not have much to say at this stage with regard to characteristics. As I explained to the committee, these are existing characteristics taken from section 16.2 of the Constitution, and then section 9, and then also Papuda. And we are well aware of the fact that offences are being committed against persons who have these characteristics, and it's not a question of me just merely bumping into someone and that person attacks me. There's that intention behind it, because that person might have an intolerance towards me that does not fit that person's set of mind or point of reference. I don't know whether you would like to maybe take the question from Mr. Swart at this stage. Thank you, Chair.
Thank you. Honorable Swart.
No, thank you, Chair. I just wanted Mr. du Preez to repeat what he said earlier about pregnancy, marital status that were excluded due to them being equality provisions, which I understand. So then if one looks at the first one, for example, age, can the department give any evidence to the committee that there are hate crimes that are committed because of age? We can appreciate that elderly people are more vulnerable to crime, but that is what the debate must be about in the public discourse, to motivate the creation of a specific hate crime, that crimes are committed against people because of that they are aged, that they are elderly, specifically out of a hatred for the elderly. And I don't know if I've ever heard of anything like that. So that's why one needs to discuss each one of these. I can understand many of these should be inserted, but just on the issue of age, for example, I would like that. Yes, we understand that it is inserted in section 9, but that's an equality clause issue. It's not in section 16. It is also in Papuda. That again is an equality provision. So that's why we need to discuss. Let's start with age, which is probably a more something that we should discuss. Thank you, Chair.
Thank you, Honorable Horn.
Yes, Chair, in addition to what the Honorable Swart has raised, the point was made previously that in order to even in the case of hate crimes, for the legislature to specifically if we're going to deal with a closed list of characteristics, each one of them has to be justified in the sense that we must be convinced that there has been already up to now crimes against that people who in an immutable manner are part of a group against whom there has been a systemic discrimination. Internationally, the test is even to the point where if a crime against somebody based on age is committed, a hate crime based on intolerance, prejudice, or hatred against older people, the systemic nature of it must be of such such a manner that it would A, instill fear in all older people, and B, it would mean that older people would consider adjusting their way of life in order not to fall foul of a similar type of hate crime. So that's in terms of international law, the origins of hate crimes. I don't want to repeat the fact that we've seen hate crimes first being introduced in the United States of America when the Ku Klux Klan made had a resurgence, and in Europe when neo-Nazism came to the fore again in the 80s. But it would seem that if we're going to stick with, for example, age, just simply on the basis that we have had isolated incidents in this country where old people were targeted because they're old, that I don't think we can claim to really be making introducing hate crimes legislation as hate crimes legislation is understood internationally. So the plea remain, as the Honorable Swart has said. Can the department give us, in a way, more than just a reference to a number of isolated crimes committed against older people, an indication that this government has come to realize that there's a big danger of a scourge of crime committed against older people because they are not seen as soft targets because they are older people, but because there's an intolerance and a hatred against older people. And unless that is what the department can put on the table, then from our point of view, we are undermining the concept of hate crimes legislation by introducing this specific criteria. Thank you.
Thank you, Honorable Buitenbach.
Thank you, Honorable Chair. Yes, I agree with both the Honorable Swart and the Honorable Horn. And again, I would like to request, I don't know if there's anyone on this platform from the National Prosecuting Authority, but I would certainly like to hear from them, or perhaps somebody from the department can answer the question. When I asked the question last week, Mr. Dupré was at pains to point out that you get, if you charge for murder, you can still get assault and assault GBH and whatever. I'm perfectly aware of that. Thank you. The fact of the matter is you're elevating what is a legitimate circumstance in aggravation that is provable from mere say-so from the bar and from evidence led and from appearance, and you're elevating it to an element of a crime which must then be proved beyond reasonable doubt. So in my view, you're making it much, much harder to prove these specific offences than it already is. And I'd like to hear the views of a prosecutor in that regard. Because if you fail to prove it, you will be unable to use that as an argument in aggravation of sentence. If you fail to prove that a crime was committed as a result of a hatred for age, then that is cadet quaestio as far as the court proceedings are concerned. You'll not be able to revisit it. The defense will make a serious objection and they will, in all probability, succeed. So in my view, you're making the prosecution of these matters exponentially more difficult. And I'd like also to get more information on that. Thank you.
Thank you, Honorable Taylor.
Thank you very much, Chair. Chairperson, I'm going to disagree with my colleagues on this point of age. I think these discussions must assist us, Chair, to cover even the areas that some of our colleagues are not aware of, or maybe let me put it like this. In South Africa, we have different cultures, Chair. We are a rainbow nation. Sometimes you might not know what is happening in another. Like, I want to make an example. The reason why I say this issue of age must stay here. Chairperson, we might not have lots of cases to prove to the colleagues that it is necessary for this to be included. Because, I don't want to say maybe this is exposing some of the ignorance that is happening, with due respect, in our country about what is happening in the left. The right does not know what is happening in the right. The right doesn't also might not know what is happening on the left. This is the time that we need to unite this country, Chair. This issue of age is happening, is ripe in our communities. I don't want to say in the Black communities only. And it has altered the lives of the old people in a way that, Chair, in our culture, old people don't go to the homes. We are not used to that. It's a new culture that we're taking our old people to stay in the homes and all that. But now we are forced, if we are young and working, we are forced to take our old ones to go to homes because of safety, their safety. With us, Chair, in our culture, I'm just going to say that because we have to appreciate that we have different cultures and we are from different places. The apartheid and the discrimination made us to stay in different places. Maybe that is why some of us, we won't know what is happening in other areas, except that we are told by the media that this is what is happening, Chair. So what I'm trying to say, Chair, it is ripe, it is happening, and it is bad. The issue of abuse that is muted against the elderly ones. I don't know if ever maybe some of the things we must always say, because internationally is not recognized in this manner, but also internationally they don't have the situation that we have in South Africa. So we have to appreciate and make sure that we accommodate everybody, and everybody must feel that when they take their case to court, they are treated the same and they are accommodated. So my view is that, Chair, let's this one, if our colleagues really are not exposed, with due respect, I can't say that because we see things different. We are coming from the community or the culture where our elders must be respected. And today they are being raped because they are old. There's a new culture now, Chair, that these old ones must go discriminated. I know it might be the issue of equality, but there are things that are happening, horrible things that are happening against the elderly. Even if you can go to the social workers, you can get stories because they are the ones who are dealing with them closer. So in short, Chair, I might be alone, but I feel that the issue of age must be accommodated, Chair. Thank you.
Thank you, Honorable Chair. Honorable Nuvot Rocham.
Thank you very much, Chair. And good morning to all the honorable members on the platform. And thank you to the department. I would like to support what Honorable Maseko Jele has just raised. There are some things that the general public is not aware of, but these things are actually happening. Things that are not printed in the normal media, that you will not see in the newspapers, but they are actually happening. And therefore, I would like to support what Honorable Maseko Jele has just raised. Many things happen within different cultures that we don't know about. Maybe it happens internationally as well, but we don't know. Like, their cultures are different. So what the department the department can say whether they're going to keep it or not, but I firmly believe that the matter of age should be included. Thank you, Chair.
Thank you very much, Honorable Swart.
Chair, may I just add, I'm fully appreciative of vulnerability of aged people, particularly in communities, and that I think is a very important point. And we know that the Older Persons Act makes it an offence to abuse any older person. That is a specific offence. We know if there's murder that is created, that is committed against an elderly person, as in the research document points out. But what we are doing here is we are elevating a hate crime. So the prosecutor has to prove that that person that commits a horrendous act against an elderly person actually hates old people or young people, for that example. So that is an element of the crime. I am not saying that we need to do everything in our power to protect elderly people. The existing law does exist, but to elevate it to prove that those horrendous acts are actually committed out of a hatred towards old people is not easy. But the issue is quite correctly pointed out by the Honorable Maseko Jele that aged people, elderly people, are vulnerable in communities. And I think that's where we need to just understand the subtle difference here, that we are actually elevating this to a hatred of older people as opposed to vulnerability of elder people that we do need to address. And we, at the end of the day, have to take that decision as a committee. The department will advise us and guide us, but I think this is where we need to take the decision. Thank you, Chair.
Thank you, Honorable Swart. Honorable Horn.
Yes, thanks, Chair. Once again, I agree with what the the Honorable Swart has said, and let me immediately say that of course none of us wants to see the frailty and the vulnerability that is a characteristic of becoming older, and that I want to say is the case irrespective of in which community you live. It is a fact of life that as one becomes older, you are physically, emotionally, and socially more vulnerable. And as a legislature, one is mindful of that, and of course, as lawmakers, one must always see in as how far or what measures can be introduced in order to not unduly expose those who are vulnerable to ill treatment or crime. But the Honorable Swart is quite correct. There's a vast difference between an obligation to look after the elderly and not discriminate against the elderly, and declaring as the lawmakers of this country that the discrimination and or crimes committed against the elderly as a group, purely because they are older and a prejudice or a hate has been formed against them because they are older, is now of such a nature that we are declaring this to be a potential systemic type of behavior which must be addressed through hate crime legislation. And the plea once again is that we must be very careful not to declare something a hate crime which is not purely pointed out as the type of criminal activity that has now become systemic in this country and therefore calls out for specific treatment. Lastly, I want to say, Chair, with the greatest of respect to the two colleagues from the ANC who has advocated for us to include this. As lawmakers, we simply cannot justify including these characteristics, elevating crimes against a group of people as hate crimes, just based on anecdotal information. We strongly are of the view that for us to justify these characteristics, much more ultimately is needed. And in saying that, it doesn't mean that we are unsympathetic to the plight of, for example, the aged. It just simply means that we must take up the burden of making constitutionally compliant legislation. And once again, it cannot just simply be that we based on isolated incidents. My two colleagues refer of things that are not known generally that is happening in certain communities. I want to venture the opinion, Chair, that in between social development, the South African Police Services, and as the Honourable Breitenbach has said, the NPA, if that is the case, then we must source that evidence in order for us to be able to say we can justify including this specific group in terms of the characteristics. Thank you, Chair.
Thank you. Deputy Minister.
Thanks, Chair. Let's just take a few steps back. What rights of a person are being affected by having a matter declared a hate crime or being prosecuted for a hate crime or convicted of a hate crime? Yes, when we get onto the grounds which are for hate speech, that is a more serious limitation of rights because that's limiting freedom of speech. What rights are being limited under the characteristics? Basically, to have committed a hate crime, you've got to have committed an offense, the underlying offense. Without that, no hate crime. The issue is, was that crime you've been committed motivated, not, Mr. Swart, by hatred, but what is in the bill is prejudice or intolerance because of the characteristics the person has. So it's not hatred, was it motivated by prejudice or intolerance? Did you, as far as we're dealing with age, did you attack the person simply because they were an older person? It's up to the prosecution, and remember we've had it that it's DPPs delegated that must decide whether to prosecute or not. So it's up to the prosecution to decide, can this meet the elements? With respect to Honorable Breitenbach, I mean, Honorable Breitenbach's motivation is not for hate crimes. Her view is that this is best dealt with as it is currently, where you lead evidence in aggravation of sentence, which I presume would be on the basis of balance of probabilities. I don't know whether I would imagine you would have to prove beyond reasonable doubt. This is now the element of the motivation beyond reasonable doubt. So it's two different issues, but it's up to the prosecutor to decide whether they want to charge the person. What rights are being lost under the characteristics by adding to the list? We've dealt with quite extensively before that there are no statistics committed. There are no statistics relating to many of these crimes. Because they don't have the documentary system. We've spoken about the fact that we need to be preemptive. So yes, I'd agree age is more borderline, but as Honorable Maseko Jele has said, people do get abused, attacked just because they're old. Women get, and this was a point she'd actually raised in an earlier meeting, women do get attacked and killed for being witches. I don't think young women are attacked. There is an age element in that. But my point is really, what are we losing? What right are we limiting by putting these provisions here? Yes, when we come to grounds, we're limiting rights. We need to have a different inquiry. But what are we actually, let's say that I mean, maybe there won't be any cases. It's an option for the prosecution. We give them the option. We put a closed list because we thought it is easier, and I think this is correct for the courts to have a list and the prosecution to have a list. We put down age. Nobody is actually ever prosecuted for hate crime with age as the motivation. Is that such a train smash? Somebody comes along, very serious person who beats up old people just because they're old, nothing else. That's a hate crime, quite obviously, for that to happen. Could that happen? Yes, I think it could happen. So, Chair, I don't know how long we're going to debate age, because, for example, when you get to albinism, which I'm just using this as an example, there are many cases, well, there are cases where people with albinism get attacked because they have albinism. I would have thought it would be clear that this should be a characteristic for a hate crime. But it's probably not that many cases, and we're not entirely sure how many there are because those records aren't being kept. So I just want to sort of raise, how long are we going to debate age for? Because those are the parameters. But my issue is with characteristics, what rights are being affected by including categories under characteristics. It may never be used, but it may also be used where somebody does go around attacking, committing crimes against older people simply because they are older. Thanks, Chair.
Thank you very much, Deputy Minister. Honorable Jailer.
Absolutely, Chair. Something disturbed me when I was not able to come in. Chair, I think the DM just covered me. I don't want to go further, especially also even the albino. We are still going to have the same vex. I'm now, Chair, about to turn 60. And as a little girl, where I was growing, and also in my where we grew up, where we were segregated, where people don't know where we're coming from. Chair, we grew up, albinos were killed. In fact, they were not killed. They say they've disappeared. We have not yet gone to the albino, but I wanted to say, Chair, when we go there,
Honorable Chair, confine ourselves to age for now.
Thank you, Chair. I agree, and he has covered me. Thank you, Chair.
Very much. Honorable Mulder.
Thank you, Honorable Chair, for accommodating me. I've been following the deliberations over time closely, although I haven't participated today. I'm also caught up in another meeting. But the Honourable Deputy Minister actually just answered my question as far as principles concerned and age than what we're debating at the moment. It's in the research documents before the committee, it clearly states that in South Africa, research on elder abuse is very limited, and that national elder abuse statistics do not fully reflect the extent of the abuse, etc., etc. If that is so, the same goes with a whole lot of the principles that's been included, or the attempt has been included in, or meant to be included into this act. And what I'm afraid we're doing, and it's most possibly it might be an unintended consequence, is that we are in the process of duplicating legislation that's already in place and that can deal with crimes like this. You know, Honourable Chair, one would get a serious killer who would favour blondes or young girls between the age of 20 and 25, etc., etc. And we cannot legislate to protect these groups. So the principle of including age is that goes for any principle that's included in this legislation. And I also feel that it's really not necessary to include it. And by saying that, it's quite clear to me that this act needs lots more of the deliberation before we enforce it into our, and only to find out later that we have to rectify it or amend it again. Thank you, Honourable Chair.
Thank you. Honourable Bredenbach.
Thank you, Honourable Chair. I'm afraid that the discussions have not taken this matter any further. To suggest that somebody who preys on old people does it from a motivation of prejudice against old people would be incredibly difficult to prove, because you have to prove a state of mind. And a state of mind is notoriously hard to prove. I only have about 3 decades worth of experience in doing so, and I accept that there are people who are much more experienced than I am. But state of mind is a hard thing to prove. So you've got a person who preys on old people, and you want to make that a hate crime? It's a crime where he's picking on soft targets. Old people can't defend themselves. Old people can't run away. Old people are easy to knock over and hurt or steal from. Why is that a hate crime? It's somebody picking on a soft target. And the aggravation of sentence is that all the victims were old, weak, unable to defend themselves, and therefore, apart from being an unmitigated criminal, he's also a great big bully. And you would be able to embroider on that in aggravation significantly. But to prove his state of mind, that's going to be really, really hard. And I'm not interested in hearing about competent verdicts. So you're elevating something that exists and that is useful and that can be used very effectively now to an element of a crime, and you're asking for it to be proved beyond reasonable doubt. I think that the effect of that will be is that prosecutors simply won't use this because it will be too hard to prove. And why would they use it if they can prosecute for murder and have a pile of aggravating circumstances and not do that, run the risk of prosecuting a hate crime where you can't prove the state of mind, and then you've lost the aggravation of sentence. It makes absolutely no logical sense to me to want to do that. And as far as, and that goes for some of the other categories here as well, but certainly with age, how are you going to prove prejudice when you attack old people? You're going to prove that people are attacked because they're a soft target. I'm afraid I don't agree that we've traversed this sufficiently. I agree that we need much more information about it, and certainly not. I'll flatter it and call it opinion. It's not even opinion evidence. But we need a lot more than that before we. Otherwise, we're just legislating up in the air. Are we going to say? The Deputy Minister says, it may never be used. People may never be prosecuted for prejudice against the aged. So then why are we legislating for it? Do we not have other things to do? Are we legislating in a vacuum? Are we going to say we want to put in a category here of prejudice against Father Christmas? It will never be used, but let's put it in just for good measure. I mean, it's nonsense. We can't work like that. And as for how long we're going to debate it, we're going to debate it until we're satisfied, Mr. Chair.
Are you done, Honorable Breytenbach?
The time being, yes. Thank you.
Thank you. ADG Pillay.
Thank you, Chairperson. I just wanted to add to what the Deputy Minister said earlier, but and rising from what Advocate Honourable Member Breytenbach is saying as well, the hate crime is if someone is charged with a hate crime, there is also a base crime. For instance, if you are charged with assault or with rape, that is the charge that will be put to the person together with the hate crime. If the hate crime cannot be proved in court, then it will fall away, but the base crime will still be proven. So it doesn't take anything away to say that age was a cause of the aggravating circumstance or the hate crime behind the actual crime that is being charged. So I think that's just the point that I wanted to add. Thank you.
Thank you, TDJ. Honorable Deputy Minister, or would you want to hear Ms. Botha first before you come in, or do you want to come in now?
No, you can ask Ms. Botha.
Okay, thank you very much. Ms. Botha?
Thank you, Chair. Thank you, DM. Just a minor point that I wanted to make. It was a question raised whether age is recognized internationally as one of the sort of victim selection categories that is included in international legislation on hate crimes. And it's in para 391 and 392 of our research note 2 that 57 member states of the OSCE, which is the Organization for Security and Cooperation in Europe, recognizes age as a characteristic that is frequently protected in the legislation of those 57 member states. And also just tied to that, as we speak about all of these characteristics and as we go through it, in our notes, in our research note 2, we also cover the fact that members of groups that are already marginalized or discriminated against are more likely to be targeted in hate crimes than others. I just think that that is important to bear in mind, that if you are more likely to be targeted in hate crimes if you are already marginalized or discriminated against. Thanks, Chair.
Thank you very much, Honorable Deputy Minister.
Chair, thanks. Just firstly, the issue which we had covered before of requiring research information about crimes in order to create the crime. With due respect, with many of the statutory, well, with all the statutory crimes just about that we've created that haven't been common law crimes, there hasn't been statistical evidence because they're not crimes at that point. That comes later. So one criminalizes because one sees the need that there may be a need to create a crime to deal with this particular conduct. Obviously, if people don't commit that conduct, then they haven't committed a crime. So there shouldn't be any issue with it. Just to the Honourable Breitenbach, and just to clear this up, am I correct that under the hate crime provision, you've got to be committed, you've got to have committed the underlying offence, and you have to be committed by a person who's motivated by their prejudice or intolerance towards the group? Is that on the basis of balance of probabilities or beyond reasonable doubt? I assume as it's criminal, it would need to be beyond reasonable doubt. In the issue of aggravation of sentence, evidence about the motivation, is that not led on the basis of balance of probabilities? So I'm challenging whether you're correct that if you charge the person under a hate crime, don't succeed in the B part, that you then can't lead that as aggravation of sentence because it's a different quantum, it's a different test. But anyway, that is up to the prosecutor. This law is not saying that any person who commits a crime against an older person must be charged with a hate crime against that older person. It's not saying that, it's giving the option. It may not be used, but it may be used. We may find situations where there is a person, a criminal, who goes out targeting older people, not because they're sitting ducks, but because he doesn't like older people. That may happen. And with respect to the Father Christmas analogy, I mean, we all know, but maybe some of you don't, that there is no Father Christmas. So, I mean, that with respect is not that rational. But the point is basically, what are we losing? What right are we affecting by including age in this amongst the characteristics? Thanks, Chair.
Thank you. Can I ask the members whose hands are up, are these old hands or new hands? I have Honorable Breitenbach, Honorable Maseko Tele, Honorable Horn. Are these old or new hands?
Honourable Chair, I would just like to answer the question posed by the Honourable Deputy Minister.
Okay, can I take you after Honorable Horn? Honorable Horn, is that an old hand or a new hand?
No, it's a new hand. Thanks, Chair.
Okay, please proceed, then followed by Honorable Breitenbach.
Yeah, thanks, Chair. I wanted to inquire from Ms. Botha, who referred to the 57 countries who gives protection to people who fall within the category of age or then specifically old age, whether any of those countries take the protection or in any of those countries, the protection takes the form of specifically earmarking crimes against the elderly as hate crimes, or whether the protection takes other forms of either legislative programs or social and other assistance. Thanks.
Thank you very much. Honorable Breitenbach.
Thanks, Honourable Chair. Yes, so certainly elevating a characteristic like age would, to an element of a crime, would require proof beyond reasonable doubt. It's an onerous measure of proof, not easy to meet. Aggravation of sentence is argued from the bar on normally, unless you need evidence, but normally argued from the bar on the basis of a balance of probabilities, a much lower measure of proof and much easier to meet. However, if you have based your case on the element of age and you fail to prove it, certainly there's the underlying offence that you will still get a conviction of, but that already exists. So then you've just wasted your time, taken more court time, added to the court rolls, and still achieved nothing at all. And you haven't proved it, and the court has found that you haven't proved it, then you will not be allowed to argue it again in that trial because you haven't proved it, and the court has found that. An attempt to then reintroduce it in aggravation of sentence would be viewed as contemptuous. You wouldn't be allowed to do it, and any defense lawyer worthy of their assault would object violently and in all probability succeed. So you just, it's complicating issues, that's all I'm saying.
Honorable Pretaba, were you cut or are you done?
I'm done, thank you.
Thank you. Ms. Botha?
Thank you, Chair. I see that the DM's hand is up. I wonder if you would prefer to take him because of the response to his point. Just let me know.
DM, would you want to come in now? Or
No, let her go. I was just responding to Honourable Breitenbach, but let me leave it apart from saying I disagree with her. But no, let go. I'll withdraw. Thanks.
Thank you very much. Ms. Botha?
Thank you, Chair. Just in response to the question about the 57 member states, it's covered at para 392 of our research note 2, and I've excerpted there from quite a lengthy document which looks at, and I'm just going to read the title of the report. It's a comparative analysis of hate crime legislation, and that looked at sort of a hate crime legislation internationally. And I just want to read the excerpt that 57 member states of the OSCE, which is the Organization for Security and Cooperation in Europe, identified age as one of the characteristics within those 57 member states that are quite frequently protected. And this is in relation to hate crime legislation, specifically criminalizing and making a criminal offense, where age is recognized as one of the characteristics. I hope that answers the question. Thank you, Chair.
Thank you very much. Members, I think we have had time to argue this point. Can I now suggest that we move to the next one? I think when we come back, we'll have an option of including age, or not option 1 and option 2 of including age, and those who will agree, then they will. Then I think let's move to the next one. But I think we must create an option there. And then those that are against would, yes, I think let's have 2 options. Let's go to B, albinism. Honorable Swart.
Chair, I have no objection to the insertion of albinism. I'm not sure if anyone else does.
Thank you very much. Honorable Taylor.
No objection, Chair. Thank you.
Thank you very much. C, Beth.
No objection.
Okay, thank you. D, culture.
No objection, Chair.
E, disability.
No objection from
me. F, ethnic or social origin. G.
Chairperson, my apologies.
Okay, Honorable.
I was thrown off the platform for a moment. Have we moved beyond albinism, birth, culture, and disability?
Yes, we have.
Okay, I wanted to make, with your permission, Chair, sorry to take you back, a proposal
that we should consider combining or including albinism and ethnic origin as next to race, which is currently M. Then in other words, to say a race, and maybe in brackets to say including albinism and ethnic origin. And I wanted to hear from the Honorable Maseko Jele, who was very passionate about skin color, whether we shouldn't also include skin color there.
Sorry,
in the spirit of making good legislation, I would think those could then all be, I want to say, specifically mentioned as included in the category of race, which is of course, already enjoying a special constitutional protection with good reason. Thanks.
So are you saying that albinism, race, and color should be under one line?
Yeah, Chair, my suggestion would be that given that race is already mentioned in the Constitution, one should consider after race putting brackets and saying including albinism, ethnic origin, and skin color.
Okay, that will be a suggestion. I'm not sure, Honorable Jele, are you responding to this issue? Honorable Jele?
Okay, sorry, Chair. No, it's an old hand, Chair. Let me just listen until he's done. Unless he's done, then we can comment.
Okay, Honorable Deputy Minister.
Thanks, Chair. I have serious problems with that
Chair,
proposal.
Honorable Nia Druchen, before the Deputy Minister, please, Chair.
Chair, I'm withdrawing for Honorable Nivo Drushin, if you can recognize me afterwards.
Yes, because, it was, okay, Honorable Nivo Drushin.
Thank you, Chair. I would like to ask Honorable Horn why he feels that albinism and ethnic origin should be under one line with race, because albinism has nothing to do with race or ethnic origin. It's completely different. So albinism is really, it should stand on its own. It shouldn't be in the same line. So I'm just curious from Honorable Horn why he's saying that. Thanks, Chair.
Thank you very much. Honorable Deputy Minister.
Chair, no, I mean, albinism has got nothing to do with race or ethnic origin. If anything, it is a disability. But it's a serious issue internationally. The United Nations has a special rapporteur on dealing with people with albinism only. And it is a major factor in South Africa in the commission of crimes. So I really, and I don't think race should be watered down. There's a difference between race and color. That's why it's spoken about differently in the Constitution. There's a difference about race and ethnic or social origin. And I am concerned that race is the key fault line in our society. I really think that any aspect relating to race and diluting it by adding in other groupings should be it needs to stand on its own, and albinism, people with albinism, needs to stand on its own. But I would agree with Honorable Nivo Drushin. What's the motivation for this? Because you can't say race including albinism, because albinism is not part of race.
Thank you very much, Deputy Minister. Honorable Breitenbach.
Thank you, Honourable Chair. It's been a while since I put up my hand and I've forgotten what point I wanted to make. But I think it had more to do with gender, so I can wait until this debate is over.
Maybe we just need to ask the Honourable Breitenbach if we need to revisit the points that she raised on age, if she's having problems remembering.
I know where to find the Deputy Minister, and despite my age, I know that he will run away.
Let's forecast. Let's forecast. Honorable Yako.
Nkosi Chair, I think I did want to echo the issue on albinism. Albinism is a very sensitive topic, and it's generated a lot of hate crimes against people who suffer from albinism. So it can't be lumped with a race because it's a whole different spectrum, and we can't put those together. So I just wanted to echo that albinism needs to be there and on its own because it's a separate issue altogether. And yeah, we need to respect that the hate crimes that do happen to people who suffer from albinism. Thank you.
Thank you very much, Honorable Yako. I think there was a specific question directed to Honorable Horn. Honorable Horn, are you in a position to respond?
Yes, Chair. Let me respond by saying the idea around including those along with race is really to try and through the legislation ensure that the special protection given to everybody who has been and is still being discriminated against on the basis of race and race-related matters is then I want to say extended to the fact to those groups. I don't have an issue with albinism. I think the arguments made and the information put forward in order to justify albinism was convincing in nature. So in that sense, I'm comfortable with having albinism as a category of its own. In terms of ethnicity and skin color, however, let me then put it on the table and say that unless we're going to include it as variants of racial discrimination, I'm not convinced that the arguments made put on the table previously points once again, and to my mind that remains ultimately the test, to a situation that we are faced with specifically crimes based on prejudice that boils down to hatred against specifically people of specific let's say shades of skin color or ethnic origin. To my mind, we obviously still sit with racial discrimination, and I would be comfortable if we include those as I want to say variants of racial discrimination. I'm not convinced that they can be standalone characteristics. Given once again the fact that the mere indication that people tend to even discriminate against people of a specific shade of skin color, to my mind, does not point to systemic crimes committed against people on the basis of that specific variation of skin color. And the same with ethnicity. In our country, I don't think we at this stage can justify having those as characteristics on their own, unless there is information at this stage that people of a specific ethnic group are systemically being discriminated against because they are a member of that ethnic group. I still then need that information to convince me that can be included. Thank you.
Thank you. Before I note the following hands, Honorable Yago, Honorable Chele, Honorable John Jeffrey, Honorable Nivot Duchen, I think the concession that you are making, Honorable Horn, is that we leave albinism, so you do consider that we must leave it as a standalone. And then, however...
Yes, thank you, Chair. I think, not to repeat myself, but the information put forward regarding systemic criminal activities against people who suffer from albinism has been convincing. Thank you.
Now, your issue is that ethnic or social origin should be combined with skin color and race. That is now your contention or your suggestion. Is that correct?
Yes, Chair. I'm of the view that the information given thus far is not convincing that there's systemic discrimination on specific groups of people having a specific shade of skin color or specific ethnic groups in South Africa. Thank you.
Thank you very much. Honorable Maseko Chele.
Thank you, Chair. I'm sure my colleague is trying to downplay the problem that we have when it comes to the issue of the skin color, Chair. And I think there is a reason why the Constitution put the ethnic and social origin and the color separate, Chair. He might say he's not convinced, but I have a different view. I'm convinced. Chair, I think there are so many utterances about I hate Black people. I hate them. Even the recent one, Chair, that has surfaced, that is we are facing now. The communities are up in arms because of the utterances that we heard from which we presented in that video. And it's not the only one, Chair. Sometimes, Chair, if something is not done towards you, don't downplay it. I'm not going to repeat myself in saying, Chair, we need to understand our origin. We need to understand that a lot of work still has to be done. The reason why we are sitting here trying to come up with an act which talks to those daily issues of discrimination, it's their motivations or whatever, it is precisely because of their Chair. So I don't see why skin color cannot be a standalone. Because, Chair, it is bad outside. It is everywhere in the social media. We are discriminated every day as those so-called Black. And there's nothing else, Chair, that makes people to be, when they talk about the so-called Black people and then say whatever they like in a manner that they are saying it, Chair, from the videos and whatever. Nothing else, Chair. The whole thing originates from discrimination. Even if here we are dealing with the issues we're not dealing with issues of equality, But there are elements of hate that comes from these people who are, it might not be, I understand Honorable Horn is talking about systematic. This is systematic in a manner that, Chair, it was originally systematic for us to be excluded from all the benefits that others are benefiting from. And it was motivated by hate that we are less human. So why can't we see it that way? So in short, Chair, I don't see, yes, he might see it that way, but I see it in a manner that it is very serious. Hate is the motivation element on this. Thank you, Chair.
No, thank you very much. I think, members, for us to manage this thing properly, some members are dealing with skin color, and then some are still on the issue of ethnic and social origin. I wouldn't want to tell you how to conduct your arguments, but if we are going to go in that way, can I then be of the view that as we are motivating skin color, ethnic and social origin, when we come to skin color under the last one, then we would have properly dealt with before we go to grounds, so that we don't have to come back to G, that is the skin color. Not G, I think it's PQ, skin color. So we are dealing with skin color, combining that skin color with ethnic and social origin. Is that correct, members? Is that the way you want to deal with it, or should we confine ourselves now to ethnic and social origin for now?
Chair, can we follow the list the way you wanted us to do it? Because we were doing it one by one going down. Because the reason why we are here, it is because the Honorable Horn decided to bring it up. I don't think that maybe it was intentionally that we must, unless I'm wrong, that we must deviate from what we were doing. So I think let's take it one by one.
Okay, let's come back to Honorable Horn. Honorable Horn, would it water down your argument if we were to focus on ethnic and social origin and exclude color? Would it water your argument down, or do you still want to lump them as one thing?
Yeah, no, thanks, Chair. Obviously, if it doesn't find favor, then the majority will have its way. Please just allow me to quickly respond to the Honourable Maseko Jele's statement, which
Chair, can't we speak and then Honourable Horn responds at the end? Because I have also issues I wanted to say to him on the issue of ethnicity.
No, thank you, DM. Honorable Horn, I was just asking you specifically on this question of ordering, not anything else. And you, so your response is that you don't mind us going as it is ordered here, and then we deal with skin color at the end. Is that your response?
No, I'm saying if my proposal doesn't find favor, then of course we can deal with all of them together, Chair. All of them separately as they listed there. My apologies. So I don't know, but I think I should be entitled to maybe just react to the Honourable Maseko Jele, who made specific references.
You are still coming. You are still coming. I was just asking you a specific question. I have Honourable Jele, in fact, Honourable John Jeffrey. There's also another hand. It does not have a name. It's W, and then it's you as the last one. Who is that hand that has got only W?
It's Honorable Neo Druchen, Chair.
Honorable Neo Druchen. So Honorable John Jeffrey, followed by Honorable Neo Druchen and then Honorable Horn.
Yeah, Chair, thanks. I'm quite shocked about Honorable Horn's perspectives or understanding of South Africa, that he wants to join race and ethnicity. They're different concepts. And ethnic conflict and the potential for ethnic conflict, and he doesn't sort of see the importance of it being standalone. Ethnic conflict and the potential for ethnic conflict is basically substantial in South Africa. The apartheid regime tried to promote ethnic conflicts by setting up these separate homelands for different ethnic groups. Post that, ethnicity, unfortunately, is still an issue. We've had conflict in Limpopo, in the Bhuani area, which started off because people between Tsonga and Venda speaking people over ethnic issues which could get into violence. You've had issues of if you go and go to Bukhale City and you ask people there about the crime rate there, people will generally blame Sotho people, Sotho-speaking people. Maybe they mean people from Lesotho, maybe they don't. They're more broader. During the xenophobic violence, people would be stopped in taxis and asked what a elbow is, or a knee in isiZulu. Those could be South Africans who just can't speak isiZulu. That's ethnicity. So I do think it is very much a standalone. A color is then something else. It can relate, also fall into the issues of xenophobia, where people who are darker are then perceived to be foreigners. It can raise a whole lot of other issues within different racial or ethnic groups. So, and then, Chair, the last point to make is that what is the problem of having a more extensive list on the basis that there's a likelihood that it may become an issue, a basis for a hate crime? What is the problem with that? Whose rights are being affected? It's not the same as grounds. So I just really want to appeal that I'm not sure, if there's a possibility, let's allow it in. Thanks, Chair.
Thank you very much, Honorable Deputy Minister. Honorable Horn. Sorry, Honorable Nivot Rohan.
Thank you, Chairperson. In response to Honorable Horn, I'm still on albinism. Maybe because he said, he was disconnected. I maybe didn't hear.
Sorry, Honorable Nivot Rohan. You see, if we are just going to be going back, it's not going to help us. I think there is a general consensus on albinism. So there is no point in us going back.
Okay, no, that's fine, Chair. That's fine.
Thank you very much. Honorable Horn.
Yes, thank you, Chair. And let me make it clear, I don't think, despite the fact that the Honorable Maseko Jele seemingly is of the view that I am unsympathetic to, or of a different view than her, for example, regarding the racist statement made of late. I'm not. What I actually was advocating for, and I think that has been missed by some colleagues, is that I would think that to include skin color and ethnicity alongside race, which is a term given specific and special protection in our constitution, that we actually would strengthen the protection afforded to victims in respect of crimes related to all of those different categories or subcategories. I mean, the Honorable Maseko Jele say that the latest statement made by somebody, I believe she referred to the person who said that dogs is not the problem, black people is the problem. I don't want us to get into a potato argument. To my mind, that was a racist statement, and therefore the special protection afforded to victims of racial discrimination is available to that person. The fact that there's that racist statements in our country make reference also to color, to my mind, doesn't downplay the fact that it is racist statements. What I am having a slight difficulty with is to ultimately and the context is given by the previous discussion documents, to ultimately take this as far as to say that there's also specific discrimination against people of, let's say, a darker black color in a systemic manner. Now, that brings me to the arguments made by the Deputy Minister. And I don't understand if, for example, xenophobia is then the big issue, why we not then including xenophobia, why we want to then rather talk about skin color. And then lastly, Chair, around the Deputy Minister's remarks around ethnicity and issues between ethnic groups or discrimination against some members of ethnic groups. Unfortunately, and I'm saying this respectfully, this is once again a situation where the Deputy Minister wants us to include specific standalone characteristics on the basis of potential problems. Once again, I say that cannot be the test. The test must be that there's already systemic discrimination boiling down to criminal activity against people of a specific ethnic group or origin, in order for us to, in a justified manner, treat that as a standalone criteria. But maybe to in a circular manner, just again repeat the point. I did not advocate for these either ethnic origin or skin color to be removed. I'm just of the view that we ultimately, by saying that the characteristic of race includes those characteristics, would afford stronger protection where there is then hate crimes on that basis. It is so that I'm partly motivated by the fact that I don't think from a lawmaking perspective, either of those two have been justified as standalones, but I also didn't want to advocate for their removal. So I hope that clarifies my view in that I'm not, because I am very much aware of our specific history and the context where we are as a country, not advocating for their removal, but there's a specific reason why I'm advocating for their inclusion along with race. Thank you.
Thank you very much. Members, there are two international instruments. Maybe Ms. Kalen or Mr. Dupree can respond to it. There are two international instruments that have identified color as a standalone. That is Universal Declaration of Human Rights. They treat color and race standalone. And then you have International Convention on the Elimination of All Forms of Racial Discrimination. They also treat color as a standalone issue, not lumped with race. Maybe I do think that it was important that to bring it to our attention that also this bill is not only dealing with just our history as South Africa, but also us as being part of the global village, affected by all other international treaties and instruments that we are party to. Maybe before Honorable Jelle, Mr. Dupree or Ms. Kalen or Ms. Potter.
Chair, thank you very much. And thank you for reminding us. We need to take note of the international obligations that South Africa has. And then, of course, we also take the cue from those two sections in the Constitution and Papuda. So I agree fully with you, Mr. Chair, and I would not like to add anything at this stage. I don't know whether my DDG or Ms. Puerta would like to add something. Thank you, Chair.
Thank you.
Chair, I would like to add something, please. I'm sorry I didn't raise my hand. I'm always having a problem. Okay, now I've got it. May I come in, Chair?
Yes, do.
Yes, on the issue of color, I think the one aspect, apart from what the research that we had provided on the issue of color and its prominence in the international treaties and even our legislation, the Equality Act, Equality Act, the Labor Relations Act, etc. So I think the one point that I want to make about color is that it's not necessarily one race against the other, but the issue of color as a discrimination or as a principle of discrimination comes in the same racial groups as well. Meaning that within a particular community, you may have the issue of color coming in as some form of discrimination. So I think that's the one point we need to bear in mind. And I think in the articles as well, there's a long discussion on the human rights, on the International Declaration, and the inclusion of color as prohibited basis of discrimination appears in quite a few international conventions. The economic and social and cultural rights, the civil and political rights, draws awareness of colorism within the treaty body members and draws attention to violations of human rights based on colorism. So that is a research that we had done, Chair. I don't want to go too much into it because it is stated in the document and why it is different from race or ethnic origin. Thank you, Chairperson.
Thank you very much. Honorable Jelle.
Thank you very much, Chair. No, I'm covered with color, the explanation about color. But also I wanted to say, Chair, also I note what Honorable Hon is saying, where he was coming from, Chair. I noted that one. I wanted also to comment on the issue of ethnicity, Chair, just to add. Within the communities, there's this thing of you find the other group liking to call the other group names that provoke the manner that provoke hatred in a manner that the other group can even be killed. I'll make an example. We having words sometimes calling the other group maybe let me just put it like Zulus, for example, Sutus or Zulus calling the other group into Twana. like the ants, and these ants has to be killed. And Chair, also the issue of calling each groups other Imidlwembele. So there are such names that come out of hatred. And once you mention those names, Chair, we all know we run for cover. For we know that if they are saying we are Imidlwembe or what, they are really coming, they are going to come to us and then in a very nasty way. So I think it's a very serious issue. And also we know about what happened also in Rwanda. It's a story, it's an open secret. Issue of ethnic is very important. Yeah, I was just motivating that it has to be a standalone. Thank you, Chair.
Thank you very much. Can I make the following, suggestions? One is that I think we have sufficiently dealt with skin color as we are dealing with ethnic or social origin. The first option would be to leave ethnic or social origin as it is and skin color as it is. Then the second option is to have ethnic or social origin and skin color and race clubbed as one. It will be another option so that when we come back, we know that there were these options.
Chair, but are we not going to find out first from Honorable Horn that he has withdrawn that view or what? Because to me, it was like he was no longer emphasizing it. I'm not sure for us to go that extent of having options. I just want to find out, Chair.
From listening to him, I don't think he has. The one that he withdrew was the albinism. And I think that if my summary of the discussion is right, then I think he would have raised his hand to say, no, I'm covered, and he has not. So I think that he's still of the view that we should have those options.
No, it's fine, Chair. Thank you.
Thank you very much. Let's go to, so we agree that we're not going to deal with true skin color. It has been sufficiently motivated. So let's go to gender. Gender, no objection. HIV and AIDS status, no objection. Language, no objection. Honorable Horn.
My apologies, Chair.
And Honorable Horn, before you proceed, it's now 11:10. I think it's time for a short adjournment. Can we come back at 11:25? It's a tea break. Can we come back at 11:25?
Thank you, Chair.
Thank you.
Recording stopped. Recording in progress.
Can we start?
Chair, fine by me. I don't know if your other members are here, but you did say 25 past.
We're all here. You can start.
Okay. Honorable Horn, over to you.
Yeah, thanks, Chair. We are on the issue of language now, as per your direction.
Yes.
But maybe because I was kicked off at some stage, and we can do it towards the end of the discussion, Chair, I would, with your permission, like to return to birth and culture, which seemingly was passed over while I was off the platform earlier this morning. But on the issue of language, Chair, I'm of the view that the document as provided by the department to justify the inclusion of language does not pass muster unless we can be afforded information of systemic discrimination against a specific language group in South Africa, and let's say a causal link between that discrimination and the commission of crimes based on the intolerance or prejudice or hatred of that specific language group. I don't think we can, as lawmakers, justify the inclusion of language as a standalone criteria. Thank you.
Thank you. Honorable Jelle, is that an old hand or a new hand? Honorable Jelle? Honorable Swart?
Thank you, Chair. Yes, language, I have read through the motivation. I would need more motivation because this is another of the issues that is not included in the various other pieces of legislation that we've referred to, Section 16, Section 9 of the Constitution, and PAPUDA, if I've read them correctly. And the question is whether language is not included in ethnicity. The Honorable Maseko Jela did give examples of that in the ethnicity context of different languages. And even on the xenophobia issues. So I'm not sure about that. I also missed the discussion on birth and culture, and I don't want to take us back. Unfortunately, I was also an issue about connection, but let's just focus on language at this stage. I would just need a bit more motivation on that issue. And can I just add another issue? And I think the DA makes a very important point about the distinction between characteristics and grounds lower down. But whilst we are considering each one of these issues, the grounds only exclude a small two issues. And grounds will then include all these issues except all these characteristics except those two or three that are specifically excluded.
Sorry,
okay, sorry.
Yeah,
Sorry. I'm working on, that's an updated version. I appreciate that. That's helped me. So I'll leave that point. We would just need to compare the two. That's a principal decision once we've decided on what to include as characteristics, which are then included in grounds. That's a separate issue. But let's focus on the language issue now. Thank you, Chair.
Thank you very much, Honorable Deputy Minister.
Thanks, Chair. Look, I agree. I mean, first point, what's the harm by adding on the basis that there's a possibility that there may be conflicts on this point? So that's the first point. So let's take language. I agree there would be intersectionality between ethnicity and language. I raised the and maybe issues of nationality. I raised the example of which we all know about of at times people being stopped and asked for the term for a particular body part in a particular language. And if they're not able to respond correctly, then they're beaten up. Yes, they could be beaten up because they're perceived to be migrants or people from another country, but they also could be beaten up because of an ethnic basis. But it's language that was actually that caught them out. So that's sort of one factor, or not caught them out, but it's language that they can't speak a language that then gets used as the factor which is a motivation for violence towards them. It may be that the prosecutor wants to charge them on the basis of ethnicity and language and nationality, because it's also the perceived issue, but shouldn't they have the opportunity to do that? The issue of language at particularly tertiary institutions, the usage of Afrikaans specifically has been a factor. I'm not sure if it has ended up in violence and other crimes. They've been perceived more as racial, but there is a tension over language. So the issue is, I mean, Mr. Horn refers to passing constitutional muster. I would see that as an issue when your rights are being limited. My argument here is still the question, what rights are being limited by the characteristics list? And then just if I'd understood Mr. Swart correctly, on the later version, there's a shorter list of grounds, not the omission of only 2. But I think if I've understood it correctly, but hopefully he's aware of that. But Chair, that's my response on the issue of language. Yeah, thanks.
Thank you very much, Deputy Minister. Honorable Masako Chele.
Chair, I will motivate that it stays, in a sense,
Honorable Chele, we can't hear you.
My apology, Chair, I've been muted. Chairperson, I agree with the Deputy Minister. Lots of tension has been caused by the issue of language. There are people who are not even get employment because of language. I know it might seem like a discrimination, not falling, it's issue of equality, but the issue of language, it causes problems too much in the institutions of learning, in the institutions of even at the crash levels. Also amongst ourselves, Chair, amongst the groupings, the issue of language causes lots of problems. And we might not be able, I think the department has motivated so much that if one will go there, we'll have to repeat what has already been said, Chair. Let me just say, in short, I motivate that it stays there. Thank you, Chair.
Thank you, Honorable Horn.
Yes, thank you, Chair. The Deputy Minister keeps on making the point or raising the argument along the lines of what harm can it cause for us to include this in the list. Now I want to say that I fail to understand that specific argument. I think it doesn't deal with the concept of hate crime in of what is a hate crime in a proper manner. And I must therefore keep repeating the point that in our view, to make a proper and a valid law around hate crimes, it must be informed by specific circumstances that points to crimes committed against people who meet those characteristics in a systemic manner, and which then calls for specific intervention by lawmakers. It can't be informed, the words preemptively is also being used. We are not fortune tellers or clairvoyants who can see what type of systemic criminal activity against specific groupings are going to happen in future. And we cannot make laws on the basis of potential future systemic crimes against people who are part of groups that meet these or that's defined by these characteristics. That's the first issue. The second issue, Chair, is that the statement by the Deputy Minister around the fact that Afrikaans remains a problem is very telling, in that it's quite clear that the intention of this government still is to, in a way, justify the criminalization of people who insist on exercising their language rights. And if that remains the situation, then we must register our strongest objection to this specific criteria. If in as far as the verbal justification around this has now been again confirmed. And then maybe just a complete response to the colleagues that has reacted to my statement. The Honorable Maseko Jele, I think, merely made the point that language remains problematic. She used the example of people who are not appointed seemingly on the basis of a language which they do spoke or a language which they don't speak. I would think that is equality issues and even labor law issues, Chair, and those situations can't be used to justify criminalizing crimes committed on the basis of language. I don't think that can pass constitutional muster. So, Chair, my objection to this specific criteria, specifically in light of the Deputy Minister's comments that Afrikaans remains a problem on campuses, giving a clear indication that the intention of this government is to use this specific criteria to criminalize the way in which Afrikaans students either use or insist on using Afrikaans in specific context on tertiary campuses. That cannot be accepted. Thank you.
Thank you. Before I move to Honorable Breitenbach, what time should we adjourn today? Are there any people who must catch a bus or drive to Parliament?
Chair, I will be catching a flight, but I'm not sure, but it will be the time. I think it will be that time because I'll be traveling right now to the airport because it's 2:10. I'm not sure if maybe you'll be done by then because it will be time already for preparing for sitting.
So what time should we adjourn, members? Should it be 12:30 or 1?
Honourable Chair, some of us have to drive to Parliament, so 12:30 would be more convenient.
Yes, 12:30.
Sorry, Honourable Breitenbach, is the traffic that bad between Sea Point and town?
Honourable Jeffrey, how I get to where I'm going is not really any of your business, nor do I wish to discuss it on this platform, but I do have other things to do except drive straight to Parliament.
So should we agree that we adjourn at 12:30?
Yes.
No
Yes,
objection.
Chair.
Thank you very much. Okay.
Chair?
Then Honourable,
Sorry,
Honourable Swart?
can you hear me?
Yes, we can hear you.
No, I just wanted to get an idea. Tomorrow I'll be challenged later. We're only starting at 3 tomorrow, but I will need time to get to Parliament as well. But you did give an indication we were going to discuss the cannabis legal opinion later today. I presume we'll hold that over till tomorrow or at a suitable time.
Yes, I don't think we'll be able to do it today. So I think tomorrow when we meet, we will discuss the issue of adjournment tomorrow. Yeah, so for today, we'll adjourn at 12:30. Is that fine to everybody?
Yes.
Thank you. Honourable Breitenbach?
Thank you, Honourable Chair. Yes, I also have a particular difficulty with this particular issue of language. I don't believe that it has been sufficiently, if at all, substantiated. I join the Honourable Horn in taking great offence and registering my deep concern to the comments of the Deputy Minister with regards to Afrikaans. Afrikaans is one of the 11 official languages of this country, and for the Honourable Minister to refer to it as a problem is unacceptable, to say the very least. The example used by the Honourable Minister with regards to justifying using language as a prosecutorial tool, just again doesn't stand muster. If you're stopped and asked for a word to identify a body part and you're unable to say it because you don't speak the language, and the idea is to determine whether or not you are a South African citizen or a foreigner, then it would not be possible to use that as a criteria for a hate crime, because clearly it isn't a hate crime. It's got something completely different. It's got to do with you being a foreigner, and it's got nothing to do with the language that you speak. Your inability to answer in a particular language gives you away. That doesn't automatically make the language the issue. The issue remains that you're a foreigner. So that just again goes to my argument that elevating matters that are not elements of a crime to that status just makes the job of a prosecutor so much harder. Thank you.
Thank you very much. And then Honourable Breitenbach, I think my understanding of what Honourable Jello was raising is that even among South Africans, for instance, in battles in the early 80s between Zulus and the Mampondo, especially in hostels, to identify as to which tribe or nationality do you belong to in South Africa, they would use language to determine, and then if they know that you can't speak that particular language, then you can be open up to beating or being killed. I think that was my understanding of what Honourable Jello was raising. I think Honourable John Jeffrey. Not necessarily between South Africans and non-South Africans, even among South Africans, which is something that is close to issue that we have dealt with of ethnic and social origin. But they would use language to back up, in fact, to establish whether you are non-Zulu or you're non-Sotho. Then that group that wants to attack you on the basis of that then attacks you. I think that was my understanding.
Chair, yes, I have no difficulty with that line of reasoning, and that isn't the argument that I was commenting on. But I have no problem with that line of reasoning. But you'll agree with me again then that the issue is that you are a Ponda or a Zulu, and not that you speak a different language. It's got more to do with ethnicity and tribal orientation than it's got to do with the language that you speak.
Okay, Honourable Mulder.
Thank you for recognizing me and the opportunity, Chair. Now, I would also agree that the language issue is extremely difficult, sensitive, and potentially divisive. language as a principle, not only Afrikaans. And I'm also concerned about the Honourable Deputy Minister repeatedly saying what harm would it do to include this and that. I must be quite honest, Honourable Chair, that it seems to me that we are really in the process of double legislating at the moment, where there's already legislation in place. We can take care of what we're trying to protect, and we should not create new divisions. We should try to get people together by recognizing diversity and not creating new fear and new protest and new action. Thank you, Honourable Chair. I'll be short.
Thank you very much, Honourable Mulder. Honourable Deputy Minister.
Chair, I thought that you were going to give me first.
Oh, okay. I
Yes.
did not. Honourable Masego Jele.
Thank you, Chair. Let me say, Chair, you have covered me when you were explaining that issue of the Zulus and other languages. And then I wanted, Chair, to caution us that we should not reduce this thing to Afrikaans, Chair. It's not about Afrikaans here. We are talking about language as a principle and language as a whole. So if we are going to keep on coming to the issue of Afrikaans, because even last time there was a sense that it seems as if this issue of putting language here is attacking Afrikaans. I'm not sure why we should really go to that far, because here we want to make sure that this issue of language should not be used, Chair, in a manner that we really feel it causes hatred among our people. So if, Chair, example was made with Afrikaans, maybe let's say for now, can we just come back and talk about this issue of language as a broadly and not talk about the issue concentrating on saying Afrikaans, because now we will be derailed and limited to the discussions when we have to defend the issue of Afrikaans. Thank you, Chair.
Thank you very much.
Chair, my hand is up.
No,
Chair, I'm not sure if the DM want to do it. Yes. Chair, did you want the DM before me or not?
No, I think the GM will be the last one.
I just wanted to agree with the Honourable Maseko Jele in singling out Afrikaans, and it is the reason why it came up in the previous meeting was the department raised particularly Afrikaans, and today the DM has raised particularly Afrikaans, and so that is a concern. But I want to, as the decision we need to make, agreeing with Honourable Maseko Jele, is that there are many other languages involved as well. And the issue is, does ethnicity cover language? And I think that if it does, then I would think it's not necessary to include it, because we have to justify why we're now adding a ground that is not included in the three pieces of legislation, Section 16, Section 9, and Papuda. And there's nothing to prevent us broadening that, but we do need to justify it. So that is just what I wanted to add to the mix. Thank you.
Mr. Chair, I apologize. I'm struggling to raise my hand, but I would just like to point out that we have submitted a document to the committee. I just can't remember which date it was, but it was after the meeting of the 26th of November, where we pointed out to the committee that language is included in Section 9.3 of the Constitution and Papuda. Thank you, Chair.
Thank you very much, Honourable Deputy Minister.
Thanks, Chair. Let me just start with Dr. Mulder's point. We want to promote a country that is diverse and where there is respect for people who are different on whatever basis. And this bill is a small contribution to that by penalizing crimes that are committed on the basis of those differences that are not being respected. I'm really surprised on the issue of Afrikaans. I used it as an example. And as I used the other example of people being questioned on their ability to speak isiZulu. What I said was not that Afrikaans is a problem. I said that there's a potential conflict at our universities over the issue, the speaking of Afrikaans. Mr. Horn, etc., Dr. Mulder then seemed to take that as an attack on Afrikaans, which it is not. It is one of the 11 languages. It is of equal status to all the others. The issue is that in those conflicts, there's a possibility not just well, I think I'm raising it more from the point of view of Afrikaans speakers at a university being attacked because they speak Afrikaans. And that is the reason, to protect Afrikaans speakers, that I am raising language as a factor for a hate crime. Not that I don't know if it's if Honorable Horn thinks that Afrikaans is always the aggressor or Afrikaans speakers. No, the majority of Afrikaans speakers we know are not white people. The issue is actually trying to deal with a situation where, because of a conflict over language at your former Afrikaans universities, that conflict may end up in violence, in crimes being committed against people on the basis that they're speaking Afrikaans, and one wants to protect them along with other languages. And those examples have been given. I just also then want to take issue with Mr. Horn saying we're criminalizing potential future crimes. I'm sorry, Mr. Horn, but that's what we do most of the time when we pass statutory crimes. They're not crimes already, they may become crimes. So Cybercrime Act, okay, you didn't support it to begin with in the National Assembly as the DA. You know, those were not, some were existing crimes, some were not. We had no idea how many there were. This is an issue where we are trying to prevent, prevent crimes from taking place by saying, look, if you do this, it may be a hate crime and you may have consequences. It may be more serious for you. So please don't. We do want, as Dr. Mulder says, to have a country where differences are recognized and respected. And actually, I take offense, Chair, to this issue that I am discriminating against Afrikaans. I am not. And if people want to try and make their own political mileage out of it, then so be it. But let's please be honest about it. Thanks, Chair.
Thank you very much. Members, can we...
So, just quickly.
Honorable.
No, Chair, I want to take us back to age because I think I need to relook at that, considering I misread the Prudent section. I just want to apologize. Language is included in those two issues. Thank you, Chair.
Sorry, your line is bad. I could not hear you.
No, Chair. I said I wanted to relook at the issue of age. I think I'm suffering from age. I misread the Prudent section 9, and language is included, and I want to just apologize for not for saying it's not included. Thank you, Chair.
Okay, no, thank you very much.
Does that mean Mr. Swart's going to revisit his views on age as well now, as I raised with Honourable Breitenbach?
Careful, oh man, careful.
No,
Person, you don't pass this one. I wanted to answer this one of, is language not included in ethnic? Chair, the reasons that we gave on ethnic, language was not mentioned, it's not included. So hence we are motivating that it should be separate. I wanted to respond on that one, Chair. Thank you.
Thank you very much. I think there are two distinct views. I think option one, it will be to include language. and then option 2 to exclude language. Thank you. Nationality, migrant or refugee status or asylum seekers. No objection. Occupation or trade. No objection. Political affiliation or conviction. Honorable Horn.
Yes, my apologies, Chair. I actually raised my hand under occupation or trade. If you'll allow me.
Please proceed.
Yes, thank you, Chair. Once again, to our mind, the test as to whether one should consider criminalizing or including this criteria is that there must be clear evidence that there has been instances where specific victims of crime in a systemic manner has been sought out by the perpetrators on the basis of their occupation or trade. Now, the difficulty is this is, of course, a fairly broad criterion. And at this stage, the only, if I recall correctly, the only justification that has been given is instances of violence against specifically sex workers. And I want to put forward the argument, Chair, that we all know that the possible decriminalization of that trade is being considered by this government, with draft legislation seemingly being prepared as we speak on this. So I'm not convinced that in the absence of decriminalization having concluded already, that it can be lawful to already criminalize actions against what is essentially, well, crimes committed against people who are essentially themselves committing a crime. In raising that argument, I'm not saying that we should not decriminalize. I'm just having a problem that if something is still unlawful, how do you give special protection for that illegal and unlawful action through another piece of law? Thank you, Chair.
Thank you very much, Honorable Deputy Minister. Would you want to come now or allow Honorable...
No, let me come now because I think this is straightforward. People will get attacked. Hawkers will be attacked. Why? Because they're hawkers. Uber drivers may be attacked by other forms of taxi drivers. Why? Because of that individual person? No, just because they're an Uber driver. Truck drivers may get attacked. Bus drivers may get attacked. Okay, I'm using more. Taxi drivers may be attacked simply just because they're a taxi driver. So I think our country is full of examples where there are crimes against groups of people on the basis of their occupation or trade. And I think it's obvious, Chair. Won't respond to the issue of decriminalization. We don't need to go that way. It's an issue of there's so many other cases where people have violence against them on the basis of their occupation or trade. Thanks, Chair.
Thank you, Honorable Deputy Minister. Ms. Botha, do you still want to say something, or you're covered?
Thanks, Chair. No, I'm covered. Thank you.
Thank you very much. Honorable Jela.
Chairperson, you know, I like the way the Deputy Minister knows the areas where I come from. Sometimes you would think that I agree with him because of he's a Deputy Minister and all that. He understands where we come from, our background, Chair. Not long, Chair, where I stay, Uber driver was, in fact, Uber drivers were beaten, Chair, for them to come to the area where taxi drivers thinks that it's their area. So this is a clear example, and many more, Chair. It's happening in another world. As I said earlier, that, you know, in South Africa, we have different worlds. So by that saying, Chair, I'm saying I support that this should stay, Chair. Thank you very much.
Thank you very much. Honorable Swart.
No, Chair, I did hear very carefully what Mr. Horn said, and I tend to agree with him. But when one looks at the broader issue of occupation and trade now, unless the page is really affected, these issues are not raised in Section 16, Section 9, or PEPUDA. So again, there must be a broader motivation. And I hear what the Deputy Minister says, and I hear as well what Honourable Secretary says. The question is, can we say that those specific groups were targeted as prejudice or intolerance towards the victim of that because of this characteristic, because of this occupation or trade? Is it merely because they are more vulnerable? So it could well be, and I'm not disputing the fact, and the DM says it's very straightforward, he might be correct. I think we just need to engage a little bit on this issue, because subject to Mr. Dupuy correcting me, I would think that these are not included under the grants already set out, Section 16, Section 9, and PEPUDA. Please, Mr. Hay, don't tell me I'm wrong again. I hope not. Thank you.
Mr. Chair, may I immediately respond, and I apologize to Mr. Horan, but I would like to draw something to the attention of the committee, and this is a case that has recently unfolded. I just can't remember precisely, and I apologize for that, what that big bus company's name is. But the owner of the bus company actually, after years of them, the drivers of those buses, being attacked merely because they are driving that bus, and they are actually competition for local transporters. But I will look for the case, Mr. Chair, and I'll bring it to the attention of the committee. It might just take a bit of a while for me to get that case, but there is a very prominent case, and the case was actually instituted against the Minister of Transport, and it was a case in the High Court. It caught my eye. I'll get back to you, Chair. Thank you, Chair. And yes, no, occupation is not part of the listed grounds in 16.2093 of the Constitution.
Thank you very much. So, Honorable Swart's line was very bad. Is he saying that he supports Honorable Horn?
I just question, I just said we need to debate the issue because it's not included under those grants. So we're extending it beyond the grants of Section 16, Section 9, and PEPUDA. I think that is very, and the case that Mr. Dupuy is referring to is the Intercape bus case, where the government is ordered to protect Intercape buses. Thank you, Chair.
So,
thank you, Chair.
Would you say that if a case is made out but is not part of Section 16, it should not be included? Only those that are listed in Section 16?
No, Chair. What I'm saying is when we extend it, just as the Kulani judgment extended it, there must be justification and motivation to go beyond Section 16, Section 9, and computer. Can you hear me, Chair?
Yes, we can hear you.
I'm not sure why. Yeah, that's the point I want to make. With the issues such as the next one as well, political affiliation and conviction, those are broader than what was set out in those three pieces of the Constitution and computer. Thank you, Chair.
Thank you very much. Honorable Horn.
Yes, thank you, Chair. The Deputy Minister says it's straightforward, but I, with respect, want to say it is not necessarily as straightforward as he makes it out using the examples he used. It's quite clear from the examples he used, specifically in respect of Uber drivers, bus drivers, and long-haul truck drivers, that it is not necessarily a prejudice or a hatred against truck drivers per se, Uber drivers per se. It is all about, I want to say, trade wars, and limited to specific areas. So I don't think that can necessarily satisfy the concept of choosing one's victim on the basis of being in satisfying that specific criteria. Then, in addition to that, in respect of specifically walkers, but also to an extent Uber drivers and long-haul truck drivers, we also, of course, all know that it is also to an extent, in some instances, rather a xenophobia that comes into play than choosing a victim because they meet the specific criteria of being part of a specific trade or occupation. So I'm still not convinced that we have that type of systemic discrimination against specific tradesmen or people having a specific occupation in South Africa that will justify the inclusion of this as a standalone criteria. Thank you.
Thank you. Honorable Maseko Chela.
Thank you, Chairperson. I think the issue, I think you have covered me on the first one, the question, because I was going to ask that, because the issue of a matter not being included in the Constitution has been dealt with before. We spoke about that one. But now we are motivating on those that were the submissions, which are not listed on section 16, Chair. So here, Chair, the issue of the fight and the tensions that arises from those who are trading and occupation and trading, Chair. It's the issue, for example, Chair, the issue of space. Sometimes they fight. They fight for the resources. They fight for, you will never go there because it's you can't do that. It belongs to us or something like that, Chair. So it is deep, Chair, in our areas. It is important that we should not leave this one, Chair. It is not the issue of the hawkers only. Even the issue, it has been mentioned a little bit, the issue of sex workers, Chair. It is not listed on section 16 PEPUDA and all that, maybe because then remember it was illegal.
you wouldn't even talk about that thing. It was a taboo to talk about sex workers, Chair. So now, if we are saying this now is allowed and we are not legislating for this, Chair, the challenges and the problems that are coming from this, how will we protect those who are affected? Chair, I think it is important. I might not be able to go further motivating them in a manner that will convince our colleagues who are against this. But Chair, this is very important in a real life. Thank you, Chair.
Thank you, Honorable Zelle. Honorable Deputy Minister.
Thanks, Chair. Look, two issues. One, these are characteristics, not grounds. So let's leave out Clause 16 of the Bill of Rights on freedom of expression and Koilane, which was around freedom of expression. In Clause 9 or Section 9 of the Constitution, it's an open list, and that's about issues of discrimination. And you can have discrimination but not actually have other crimes flowing from that discrimination. But on this issue, I mean, Mr. Horn refers to trade wars. What crime is trade wars? You'd get charged with the maybe different conspiracies, and you'd get charged with murder, arson, whatever, but there's no trade wars. Yes, to some extent these are about, or not to some extent, these are about trade wars, but let me more widely define it as competition over access to resources, the transport routes, for example, how things are being sold, as in the case of the hawkers. So it's competition over resources. That poor Uber driver who got attacked and got killed maybe, or badly beaten up, they're not attacked and badly beaten up because of who they are as a person. They're attacked solely on the basis that they're an Uber driver and they're in competition with other route drivers. Maybe Honourable Horn should speak to his colleagues from his party in the Western Cape in terms of the conflict there, relating, I think, to the cancellation or non-renewal of a contract involving taxi drivers and the attacks on bus drivers because of that. And that's nothing to do with xenophobia or nationality issues. It is just the identity of the group that the person belongs to, the occupation or the trade that they are conducting. But Chair, I just want to say that to my mind, yes, occupational trade is not in Section 9.3, Papuda builds on 9.3 of the Constitution, but it's clearly an area where there is violence against people on the basis of their occupational trade. And if I can move on the same with political affiliation, it's not there. But hey, Mr. Swart, you know the history of KZN. How many people died? How many people had their houses attacked, burnt, arson, murder, assault on the basis of different political affiliation? And there's still issues of political, it's reduced, but there's still issues of political affiliation in our country. And remember, none of these are actually that we are, well, specifically occupation and trade and political affiliation. We're not saying they should be grounds because of limitation of debate and freedom of speech. Thanks, Chair. But I think, Chair, I don't think we're going to convince Mr. Horn, so I would suggest you put it in as an option 2 of excluding occupation or trade. And if Mr. Swart wants political affiliation, then the same thing.
Can we proceed in that way under occupational trade and political affiliation or conviction? Then can we go to I think even under political affiliation and conviction, can you go to race? Any objections? Religion?
Sorry, Chair. I just wanted a debate around this issue. I'm not holding to a certain view. So I'm not, given what the DM has said, and maybe we should leave the option under political affiliation of conviction. I'm fully aware of the issues that he does raise, and if I simply point that I just wanted to make is because they're not included in Section 16, Section 9, and computer, we need to have a discussion around it. So maybe when we get to the final decision, I don't know what other members feel about political affiliation of conviction. I'm quite open about that, given what the DM has said and the need for, as he indicated, prejudice or intolerance towards a victim because of their political affiliation or conviction. Maybe this is one that we do need to include, but maybe let's not hear what other people's views are. I just wanted to have a debate on this.
Your line is very bad. Are you saying that you are fine with political affiliation, but we need further debate?
No, I just wanted a discussion around that, and it seems that if there's general broad consensus around that, then we don't need options. But I just wanted a discussion around that. Thank you, Chair.
But there is no one who has raised. Honorable Horn.
Yes, thank you, Chair. Obviously, we are all aware of specifically political killings in KZN. And in that sense, I do understand where the initial justification for this comes from. Although, and I'm not from KZN, I know the Deputy Minister is, so I may stand to be corrected and maybe he can just enlighten us. But my sense is that the specifically the political violence and the resultant crimes being committed between specifically the IFP and the ANC is primarily something of the past, and that unfortunately one gets the sense these days that it is quite often intra-party conflict that leads to political violence in KZN, but I may be incorrect. So in that sense, I have some sympathy towards inclusion. Where I am, however, worried, Chair, is that we've already had instances in this country where, for example, people were subjected to criminal prosecution based on, for example, hand gestures made against certain politicians. And we also know that, worldwide, let's not use an African example, but even of late when the crown was passed over in the UK, I read some interesting laws that are still in place there about how one cannot insult the king or the queen or whatever, and how simple basic statements of criticism can be construed as that insult and then lead to criminal prosecution. So the difficulty, the potential pitfall around political affiliation or conviction is that this can be used ultimately, potentially, the Deputy Minister is fond of saying potentially, so I see a potential here that it can be used to stifle political debate, specifically when one links this to political speech. And in that sense, I believe we must be very careful before including this, because it can lead to having a chilling effect on free political debate in this country if one looks at the way in which speech-related and, let's say, gesture-related political actions can lead to criminal prosecution. Thanks.
Thank you. Deputy Minister.
Yeah, Chair, I don't know why Mr. Horn raises this. Political affiliation or conviction is not, and occupation or trade is not included under grounds. So even in the introduced bill, you'll see it immediately under on the screen. We didn't have them in precisely not to interfere with freedom of speech and freedom of debate. So I don't know why he's raising it. Let him raise it if somebody wants to argue that they should be there undergrounds, but they're not. So it's a waste of time raising it. Nobody's saying they must be there undergrounds because we don't want to restrict freedom of speech. Gestures, I think, can be would fall under hate speech, could be, but it's not included under the grounds for freedom of, under the grounds for hate speech. And also, obviously, remember that there has to be, for a hate crime, there has to be an underlying crime. So you have got to have done something else. You've got to have beaten somebody up, partially, very badly, whatever, or killed them on the basis of their political affiliation or conviction. And I would say, look, we've got issues of political tolerance. By the way, it wasn't just KZN, it was Gauteng, it was Free State, it was Mpumalanga particularly. And I do think that this, having this in, protects people. So this is not, again to repeat, this is not therefore a ground for hate speech. So unless somebody raises that it should be, let's not talk about it stifling debate or freedom of speech. But I do think that given the fact that I thought we should be aware that political tolerance in South Africa is not that great. And you could have people being attacked on the basis of their political affiliation from all our parties, not just ANC and IFP. That was historical, but from all our parties. Thanks, Chair.
Thank you. Members, I would appeal that as we differ, let us not invalidate our right to speak or to raise issues. It would have a potential of defocusing us. Let's raise our point of differences, but everyone has got a right to air his views or her views, even if we think how wrong it is. Honorable Horn?
Chair, don't pass me.
Oh, your hand is up. Okay, sorry. I thought it was an old hand. Mamujele?
Okay, thank you, Chair. I think I wanted to emphasize the issue of saying if it happens before, it happened before, it has a potential to happen again. So hence we have decided, we motivate that it should be there on the characteristics, the issue of political affiliation, Chair. And also, I agree that it was not only in KwaZulu-Natal, it was all over, even in Gauteng, we felt it happened. And here we are not talking about the internal squabbles of the ANC. Even DA, they do have squabbles. They might be smart. Sorry, Chair, maybe if I get it right. Thank you. Thank you, Chair.
So thank you. Honorable Horn.
Yes, Chair, thank you. I mean, the point the Deputy Minister makes maybe must now bring us to that point where we talk about the fact that, of course, hate speech and the hate speech provisions in this bill is not to be strictly, let's say, isolated from the hate crime provisions. Because if this bill is passed, then hate speech could also be the underlying crime. So by merely saying that the speech part is not included here is not a absolute safety net against speech being dealt with by way of the hate crime provisions ultimately, unfortunately. And once again, at the risk of repeating myself, I have full sympathy for the fact that we have had political violence and crimes in this country.
If you look at the proposal, maybe Mr. Dupree, if you can just go to it, that is on page 7 of the working draft. Proposal 1. Okay. Members have this. A hate crime is, and so this is what we are proposing to the committee. A hate crime is an offence recognized under any law hereinafter referred to as the underlying offence. Look at the blue bit, Mr. Horn, excluding an offence referred to in section 4.1. So, hate speech can never be an underlying crime. Thank you.
Thank you very much, Deputy Minister.
Chair, if I may come in, I stand corrected. I obviously missed the specific meeting where the blue part was inserted there. Thank you.
Thank you. Let's go back to, I think we would have, what is this thing, political affiliation or convention as option 1, and then option 2 is to exclude it. Race, religion, sex, skin color. We've already dealt with skin color. Members, can I propose that we end here?
Sorry, Chair, you left out sexual orientation, gender identity, or expression.
Okay, sexual orientation, gender identity, or expression, or sex characteristics. But can I propose, members, that we will deal with sexual orientation, gender identity, or expression tomorrow, and then we'll start with the grounds. The reason for that, I would like us to use the 3 minutes or 4 minutes left to, one, discuss the approach for tomorrow. Tomorrow is our last day as the committee, and I would propose that maybe instead of starting at 9:30, we start at 9. We finalize the outstanding minutes. I think the legal opinion was circulated. We can just briefly discuss the way forward. I think we have read the legal opinion and the areas it covers. We can just discuss the way forward as to what needs to be done, and then we start with the bill. So the firm proposal, members, is that we don't start at 9:30. We start at 9, because it's quite clear that if we start any time late, we might not be able to push to the extent that we would want to push with this bill. And tomorrow it's our last day. And I think also I propose that because some members will be traveling, tomorrow we finish at 1. Those are my proposals that I would like to propose, that to put to this meeting for consideration and possibly approval. Honorable Stephen Swart and Honorable Nivo Drochen.
No, Chair, I don't have a problem with your suggestion. I would ask you to start with the minutes. I might be a little late because I have to travel early. I'm coming in earlier rather than later, but I don't have a problem with starting at 9. So is it my understanding we'll start with the minutes and then the legal opinion, and I'll do everything required to be there by 9. I might be a little late. Thank you, Chair.
Thank you very much. Honorable Nivo Drochen.
Thank you very much, Chair. Just to alert the committee, perhaps if I'm correct, plenary is scheduled to start at 2 tomorrow, not at 3, as it normally does.
Oh, okay. Okay. So can we finish at 12:30, the normal time? Is that
yes, Chair?
Is that fine? Okay.
Maybe you should organize a Uber driver. That's assuming that there aren't the likelihood of hate crimes being committed against you, or for Honorable Breitenbach, so she can make it to Parliament in time tomorrow.
No, thank you very much. Thank you very much, members. On that note, can we just adjourn for today, and then we meet at 9 o'clock tomorrow? Can we ensure that all minutes are circulated today? I know they've been circulated. Can we all read them so that we are able to dispense with them quickly? Thank you very much, members. Thank you. The meeting is adjourned.
Thanks, Chair.
Thank you.
Thank you, Chair.